pleasant afternoon or evening, depending on where you're joining us from today. My name is Ryan Milburn. I am the president of the International Casino and Resort Working Dog Association. And today we are hosting a webinar for canine case law specific to explosives and patrol handlers. We're very fortunate to have a very special guest today, John Peters, who is a very well-known canine legal expert. You've probably seen his name attached to casino multiple canine conferences all around the country. He's done seminars for police departments and agencies all over the country. We're very fortunate to have him today. Before we get into that, just a couple things real quick. Um, so, just a couple reminders. Please, when you join today and throughout your time, please make sure that your microphone is off and that your camera is off. As this is a question and answer period, John has a presentation for us that he's going to give here in just a moment, but we are taking questions. Please feel free to ask any legal questions specific to canine today, whether it's explosives or patrol oriented. FLSA, we already have some great questions about that. Accidental bites. There's all kinds of stuff on the slate for today. But please ask your questions in the chat function. And when we get towards the end, we'll be giving all those questions to John. So this is also a little background on John, if you didn't get that in the email, but very much big thank you to John for coming today. Also want to thank some of our sponsors, Pinnacle Protection Group. Thank you for helping sponsor and make these type of webinars possible. And also a shout out to the Australian Working Police Dog Association for helping us out and letting us use their Zoom account today. So thank you guys for that. I'm going to go ahead and turn this over to John, who should be. Go ahead and turn on your camera and your microphone there. Awesome. Welcome, John.
Hey, good afternoon, everybody. Well, I have to say it is good afternoon, even though it's evening here. So
Fair enough. Well,
yeah, Ryan, thanks for the invitation. Always glad to speak to your group, and I greatly appreciate what you do for the profession, and I hope that
thank
everybody
you.
here does as well.
You're very
Um,
kind.
yeah, as far as the class today, let me just preliminarily say this. Normally, when I teach my regular class, it's about a 6 hour class. So we're operating with a very condensed window today of about 2 hours. I want to respect that time. I'm going to try and shoot for a short break around the 1 hour mark, just to kind of let everybody stretch their legs if they want to and stop listening to me. Um, I think we're going to cover a pretty good overall examination of both private security concerns and public law enforcement concerns. So that's a little bit different than the normal class, but I think we're going to cover them well. Everything we're going to talk about today kind of begins and ends with the Fourth Amendment, whether it's search and seizure or use of force. So we'll get into a number of topics, and then I want to leave time at the end for specific questions and answers. I've already been given about four that Ryan has forwarded to me, and we'll address everyone. In fact, I'll stay on and answer every single question that you have as long as you are willing to stick around. So with that, I'm going to bring up this slide presentation. Let's hope that this whoops. Okay.
All right, I can
Great.
see it. There we go.
All
It's
right,
up.
everybody ready? Then we'll get into this so we can cover what we need to cover.
Awesome. Thank you, John.
Sure. So everything, like I said, for what you do in law enforcement as public law enforcement is governed under the Fourth Amendment, whether it's search of a person or property or the seizure of a person or their property, or whether it's the use of force, which is in fact a seizure. Um, the test under the Fourth Amendment is whether that search or that seizure is reasonable according to the current law. And It only applies to government or public law enforcement officers. So if you're in private security, you are not subject to a Fourth Amendment test for the actions that you take with your dog. It's totally outside of that, unless you're acting as a government agent. We'll talk about how that's determined. The Fourth Amendment determines whether use of canine force to apprehend a suspect is reasonable. It determines whether the search of personal property, a locker, a vehicle, a person is reasonable. And reasonableness is a test that the court uses by balancing what's called the government's interest or society's interest in seeing a particular law enforced against the individual's liberty or privacy interest under the Fourth Amendment. So it's this constant balancing of those two interests. When one outweighs the other, then the weaker one has to yield. So that might be the individual interest in some cases, and in other cases, it may be the government's interest. So let's talk about some concepts for Fourth Amendment purposes that you commonly are going to deal with. Reasonable suspicion of criminal activity. What is it? As the courts say, it's a particularized and objective basis for suspecting criminal activity by the person who you have detained. Now, the key words there are particularized and objective. So it has to be something more than a hunch or a suspicion. Let's say you're dealing with an individual and your radar's going off. It's something you know is not right, but you can't point to any objective facts to support that suspicion. At that point, all you have is what we call mere suspicion, and that is not enough to detain an individual, search, or seize them. Um, the other thing I want you to remember about reasonable suspicion is oftentimes individual elements by themselves are not enough to constitute reasonable suspicion. Examples I put here: previous criminal background or nervous behavior by the individual. By themselves, courts will typically reject and say no. It's not necessarily evidence of criminal behavior. But when you can start to link two or more elements that point towards criminal activity, then your reasonable suspicion becomes stronger. You don't need to have 8 elements to establish it, but these single elements by themselves just may not be enough. So anytime you believe that reasonable suspicion may be challenged or the basis for your detention may be challenged, you want your report to record those objective facts that you based your reasonable suspicion on. The Fourth Amendment creates what we call zones of privacy protection for individuals and their property. So the first dividing line I want you to understand is that the person always has a higher level of Fourth Amendment protection than the person's property. And the second dividing line is where either of those are located. So if you think in terms of this bullseye target example, where the center of the target is where the highest level of Fourth Amendment protection exists, that's an individual in their own private residence. Highest level of Fourth Amendment protection that exists in our society. You know that as public law enforcement, you can't just enter somebody's house and seize the person. You need a warrant to do those. Now, once that person leaves their home and moves out into the public space, you can see their protection is dropping off. Now we're in that red zone. Why? It seems curious. I mean, they're still a person. Why are they losing Fourth Amendment protection? Because they went out the front door of their house. Well, the reason is this. It's based on what we call expectation of privacy. When you're in your own private residence, you have the highest expectation of privacy possible. You're free to do whatever you want without the government invading your space or seizing you or your property without a court order. But when you move out into the public space, you just put yourself in a position where the general public is free to observe everything about you, what you're wearing, what you're carrying with you, conversations you're having, people you're meeting with, transactions you're involved in, odors coming off of you or your property. All of that you have made observable by putting yourself in the public space, thereby indicating that you yourself have a lower expectation of privacy about your person. So now the next level down would be property. Property always starts with a lower expectation of privacy than the person. So once again, when that property is contained within the private residence, let's say it's papers in a locked safe. Once again, you cannot, as law enforcement, just barge into the house, break into the safe, and start rifling through the papers. You need a warrant to do that. So the property has an expectation of privacy there. But when that property moves into the public space, for the same reasons we just mentioned about the individual, it loses a tremendous amount of Fourth Amendment protection. Not all of it, but a large amount of it. Because just like the person, you've now put your property in a position to be observed by every member of the public who you encounter and everything about that property. So keep that in mind.
And John, just real quick
Yes,
to jump on that, could you briefly touch on specific to hotel rooms? And because a large part of folks that are here today work at casinos and hotels, because I know at least my understanding is it's not as much as a home, but it's more than in public in general. And then also luggage that is being dropped off to a bell desk as
sure.
opposed to luggage that is in someone's room that they legally
Right.
purchased.
Okay, this is a good point to talk about it. It may come up in a later slide, but let's talk about it now because I think it applies. Let's take the first example, which is hotel rooms. So there's sort of this stair step approach by the courts. They start with the private residence. Then you move down to apartments. How are apartments treated? Are they the same protection as a private residence? Are they less? Courts tend to allow law enforcement to use the canine in the hallway, the common areas of an apartment building or apartment residence. One circuit, and if you're a member of, if you are law enforcement in the states of Wisconsin, Indiana, or Illinois, the Seventh Circuit says no, those hallways are off limits to law enforcement because they are the equivalent of the front porch of a private residence. And just like you can't do it on the front porch of a private residence without a warrant, you can't do it there. But the majority rule outside of the Seventh Circuit allows you to use the canine in the role of conducting a free air sniff in the hallways of apartment buildings. Now, the next level is the motel. The motel is almost universally it's an accepted procedure in almost every federal circuit that you can do this in a hotel hallway. Why? Why is the hotel treated differently? Because typically hotel guests are transients. That's not their primary residence. So that's where that distinction comes in. People who rent hotel rooms typically do so for abbreviated periods of time. It's not their officially listed residence address. It's not on their driver's license as their address or their voting records or anything else. It's just a transient residence. And therefore, the courts have held that people in those situations have a lower expectation of privacy as to the common areas. Okay, let's be clear. Now, we're not going into the hotel rooms. We're just talking about the common areas around those properties. So I don't know if that helps, Ryan.
It does. Thank you.
Okay. So this federal statute, again, applies only to law enforcement. We're not to private security yet, but we're getting there. So this federal statute imposes liabilities upon police officers when they violate an individual's federally protected constitutional right without probable cause or legal cause. The key of this is that right has to have been clearly established at the time of the encounter. What does that mean, clearly established? It means that no reasonable police officer could believe that they could do what they did and not violate a right of the individual. So, what are more specific examples? It's clearly established in the law and has been for quite a while that you cannot use force on a compliant suspect. So that's universal. That's been out there for decades. No reasonable officer could assault a compliant suspect and say, oh, I didn't realize I couldn't do that. Um, so that's clearly established. But not every right is clearly established. And it gets a little confusing when you hear the word right. You think, well, the right to be free from an unreasonable seizure, that's obviously been established forever. The right not to be subjected to excessive force, yeah, we know that that's been out there forever. So how could something be not clearly established? Well, when they say clearly established, they mean that the specific fact pattern of your deployment or your incident has already been held to have been a violation of the right. That specific fact pattern. Well, not every specific fact pattern has been examined, and therefore, not every specific fact pattern has been clearly established as a violation of a right. So that's what they mean when they say clearly established. That statute carries very heavy penalties. It not only allows for compensatory damages, but also kind of uniquely for punitive damages, which most state laws don't, and actual attorney's fees. So that cost can get very expensive very quickly. The courts also developed a defense against this claim. Qualified immunity, you've probably heard the term used. It only applies to claims brought under this statute, okay? And there's two elements for you to qualify for this defense. One, something we just discussed, which is that the right that the plaintiff claims you violated was not clearly established in that jurisdiction at the time of the encounter. If the court looks at its body of law, that federal circuit, and they say, there's no case law that would have guided this officer that what he did was a violation of the Fourth Amendment, then you get qualified immunity and the suit goes away. The second way is if you can demonstrate that a reasonable canine handler faced with the same circumstances you were faced with could have pursued the same course of conduct as you. Could have. Not would have, could have. So you're in this deployment and you've got a menu of options in front of you, A through D. You chose B, but the best choice was D. It doesn't matter. You can still get qualified immunity if you can show that a reasonable officer could have chosen B. Maybe it wasn't the best choice, but it was a reasonable choice under the circumstances you were faced with. So that's very strong. And it's why a lot of activist groups are trying to push to get rid of qualified immunity. But the courts implemented it for a reason. They didn't want this statute to become a runaway train that's running down police officers everywhere. So when the circumstances are right, they're going to hold you responsible. But they developed qualified immunity for a very important public policy reason. The idea behind your job as a law enforcement officer is that when the public needs you, they want you to act. They don't want you frozen by the prospect, what if I make the wrong choice and I get sued? So this was to take that out of your head to say, don't worry if you make the best choice. As long as you make one that is reasonable, we're going to protect you and we'll protect you from suit. Because they want you to be proactive. They don't want you sitting there thinking, oh, I don't know. C looks pretty good, but maybe B is the. They don't want you doing that. They want you to act. So what they're saying is, as long as you act reasonably, you'll be protected. Okay. So, are you private security or are you a government agent? Okay, there's three levels we're going to talk about today. There's strictly public law enforcement, there is strictly private security, and then there is private security that at times is classified as a government agent. Okay, so here are some cases that discuss the factors that determine that. So, private security acts under color of state law when that private security is a willful participant in a joint activity with the state or its agents. So you get the concept here. You're not acting strictly at the direction of your employer or the establishment that you're assigned to, but you're acting in conjunction and coordinating with public law enforcement for the goal that public law enforcement is pursuing. If that's the case, then you become a government agent, and then you are subject to this Fourth Amendment analysis. You're subject to the statute we just talked about before if something goes wrong. Um, so I think I've got a second slide here that discusses it even better. Let's look. Yeah.
I noticed that case law was from this year, from 25,
Yeah, that's very recent. Let me
and it
go
was
to
a
that.
casino. Very interesting.
Yeah, it was in New York, Resort World Casino.
I think we have a couple Resort World canine handlers on this webinar, actually.
Okay, well, welcome. That's out of the Eastern District of New York, Federal District Court in New York in the Eastern District.
Excellent.
Whoops, I'm going the wrong way here. So here's another explanation in more specific terms, a kind of a four-point test of when a private security handler could be classified as a government agent. It's when the private entity performs a traditional exclusive public function, something that's typically reserved for law enforcement. Two, when the government compels the private handler to take a particular action. Third, when the government acts jointly with the private entity. So they're not necessarily directing you, but the two of you are a team acting towards a joint goal. And four, when the private entity is intermingled with government policy or when the government is intermingled in the management or control of the private handler or organization. Okay, so that's a pretty good summation of how they look at it. And to boil it down, what they're really saying is, look, the private security is operating according to the rules of the establishment where they work. Law enforcement is not involved in this. They're not directing them. Um, they're not working together jointly. Then they're a private security company and they're not subject to Fourth Amendment analysis or penalties. But if we find that they're interwoven, they're working together and planning and carrying out things together, or the government is getting the private organization to carry out what is really considered an exclusive public function, then you could be considered a government actor or agent. And each one of these cases will look at all the facts involved. There's no hard and fast um, test for it. They're going to look at all the circumstances involved to determine whether a private security qualifies as a government agent. And they're not going to look at it at all unless that's the theory of the case that's brought by the private party. All right, so let's look at search and seizure. Um, Here's just reinforcing what I said before. The Fourth Amendment provisions that prohibit unreasonable searches and seizures, they are not applicable to private security, only to the government or the government's agents. Okay. So private security stands alone. They are free of all this analysis. They're free of the potential penalties as long as they're acting purely in that capacity. Oh, and an important point here in blue at the end. Let's say you do a search as private security, and as a result of the outcome, uh, public law enforcement gets involved. They take the person, they place them under arrest, they take possession of the evidence that you came across. That does not now make you a government agent just because the end result leads to law enforcement involvement. The analysis is whether from the front end, not from the tail end of it.
Gotcha.
Okay. Oh, here's more. So this case decided out of Indiana Court of Appeals this year as well. And they're saying there's two critical factors. One, whether the government knew of and cooperated in the conduct, and two, whether the private party's conduct was done for the purpose of assisting law enforcement or to further law enforcement's own goals. So again, it's the same thing, really. Okay. It's the test is always going to be what function were you really pursuing and what level of government involvement, if any, was involved. All right, I don't know for private security how many of you may be involved in a use of force with your dog in the private setting, but what I'm laying out here is for law enforcement. That's why I've highlighted it, and we'll go to private security next slide. So for public law enforcement, your use of force has to conform to the current law, and it should be reflected in your agency policy. It's always determined by these Graham versus Connor factors. Okay. One, what was the nature of the crime that you witnessed or what was reported to you? Was there active resistance or flight from the attempted arrest? Did the suspect present a threat of harm to you or others? Don't disregard the or others part, but that's very important. Everybody kind of blows by that like it's just extra language. There may be cases where a dog is deployed not because the officers were under a particular threat, but because some innocent people in the vicinity could have been under a threat if a particular suspect escaped or got away. So that or others is not there just to end the sentence. And lastly, what warnings were issued before the dog was deployed to apprehend by force. So this is sort of the test as to whether your use of the dog as a use of force to physically apprehend a suspect is reasonable. What I want you to take away from this is anytime you're involved in a use of force with the dog, and we're not talking about an accidental bite at this point. We'll get to that. An intended apprehension of a suspect using the dog to apprehend them by force or by biting, your report should reflect each of these elements, okay? Very important. And we'll talk about it when it comes to record keeping, but these elements are in here for a reason. Now, with respect to private security, you are not analyzed under the Graham versus Connor test. You're not analyzed under the Fourth Amendment for whether the seizure was reasonable or unreasonable. You are subjected to essentially a negligence standard. So, what is negligent? Negligent means it was unreasonable. So, it's funny, it's the same language used in Fourth Amendment, but it has a different meaning. This is a civil term here.
Hmm.
So under state law, the question is, was your conduct reasonable under under what test? What's the court going to look at if they're not looking at Fourth Amendment law, if they're not looking at federal case law on use of force? It's going to be measured by several factors. Did your use of force conform with your training, with your certification, and with industry standards? Who's going to testify to that? Well, both sides are going to have experts. In the case of private security, you're going to have an insurance company typically that will be assigned, an insurance company who will assign legal counsel to defend you. They will hire a canine expert who will come in to explain why the use of force was reasonable under the circumstances. The defense side is going to try to attack your training, your certification, and whether you met industry standards. So that's where the negligence will be proven or defeated. Okay. And also, additionally, did your use of force conform with your security agency's policies, your employer's own policies? That's really kind of the starting point. Did it conform with the customer's policy? So some of you may be employed directly um, by the business at which you work. Some of you may be contracted out to those places by a security agency, and you work for the security agency technically. So it's important that you are conforming both with your employer's policy and if your employer is not the customer, with the customer's policies as well. So it's important to understand what those are, because
Gotcha.
all of those can become a subject of challenge if you get sued over use of force with the dog in as private security.
So two quick questions for you on this. When
Yep.
you mentioned reasonable, who's reasonable? Is that what a civilian jury? Is that the reasonable?
Well, it's going to be determined by a civilian, by a civil jury. Yeah.
Gotcha.
So that's why you got to be careful. Because let me give you some nightmare scenarios about civil juries. They're typically referred to as a jury of your peers. They will never be a jury of your peers, ever. Meaning the first people excluded during jury selection will be anybody who works in private security, anybody who's a canine handler, anybody in law enforcement, anybody who handled a dog in the military, any dog trainers, anybody who could put remotely have knowledge of the subject, they are the first people excluded. Then a jury is selected. Typically, a civil jury is seven jurors, typically, sometimes eight, and then one is excluded at the end. They keep one as an alternate in case somebody gets sick. They don't have to start all over again.
Right.
And typically, it's not by beyond a reasonable doubt like the criminal standard. The civil standard is by mere preponderance of the evidence. What does that mean? It means that the evidence in favor of the proposition outweighs the evidence against it, however slightly, could be by 1%. So, and civil juries do not have to be unanimous. So it's a different animal than the criminal realm.
Absolutely.
And who do you get on these juries? Look, sometimes you get people, sometimes you always get people who don't want to be there. So they're impatient. Sometimes they're not listening, paying attention. Jurors fall asleep and nod off during the evidence. Um, their minds are somewhere else. They might have a mother who's dying in a nursing home that they're tending to, and that is far more important to them than what happened to this guy at a casino. So, believe me, it's an arena you want to stay out of because it is filled with risk. It's ironic that we're talking about casinos because I often tell people that going into a civil jury trial is not unlike going to the casino and putting down $100 on 23 red, you know.
Well, in my cop
Very
days, we always mention that every jury is 100% made up of people who couldn't get out of jury duty.
exactly. It's funny you mentioned that because when I'm on the plaintiff's end of a jury case, or I'm opening the case with opening argument, the very first line out of my mouth is I look at these jurors and I don't say anything for a few minutes, and they're getting a little antsy, like, what is this guy up to? And I'll say, apparently none of you have friends who are attorneys. Now, when I say that, there might be one or two that start giggling because they know what I'm getting at.
Hmm.
Most don't. And what I say is, because when my friends get a summons for jury duty or a notice for jury duty, they call me up. And the first thing they want to know is, what do I have to do to get off? So, yeah, nobody wants to be there. Nobody
Very
wants
true.
to, yeah, nobody wants to be refereeing somebody else's dispute. That's the bottom line.
And it's
You
super
want to
important
get
for
the
handlers
point.
to understand that that is the reasonable, because reasonable can be somewhat of a gray term, especially on the private security side.
Yeah.
But if that's the to me the best way to frame what is reasonable is what is reasonable to those 12 or 8 or whoever it is jurors. So thank you for
Right.
clarifying that.
Right now, they don't do it with no guidance. At the end of the trial,
Right.
they are given a set of jury instructions. These are standard instructions that have been approved by that state's Supreme Court, and they lay out the elements and explain what negligence is, and then they want them to apply the facts they've heard to that law to come to a conclusion as to whether this. Here's another way negligence can be understood. It's referred to as a breach of a duty of care. Did you breach a duty of care? Well, again, what determines what that duty is? Training, your certification, industry standards, your employer's policy, possibly your customer's policies. All of those bear on whether you breach some duty of care.
Excellent. When it comes to the customers' policies, we have a lot of members that work for third-party private security, and many times the client that we are servicing the canine work for has no policies regarding use of canines or post orders or anything like that. Is that a good thing? Does that give us more freedom, or is that a
I,
bad thing?
Well, it could be both, right? You're not going to find out till the proverbial you know what hits the fan, and then you're going to go, "We didn't know you were going to do that," and you're like, "Well, you didn't have any direction here for us," and so I would advise not the individual handlers, but the private security employer to make sure that they are on the same page with the customer and explain to the customer, look, this is how we operate. These are our policies. You should be familiar with them. If for some reason something in here is objectionable to you, or, you don't want us doing this in your establishment, we need to know that like ahead of time.
Excellent. Thank
Yeah,
you.
it's very important that the customer and the employer or the agency, security agency, be on the exact same page to avoid. Because the person who gets burned from the misunderstanding is the poor handler.
Yeah.
Okay,
Thank you for clarifying.
sure. Um, in use of force, the courts generally want a pre-deployment warning given before the dog is released to apprehend anybody by force. The courts are paying very close attention to this nowadays, closer than ever before. And the goal, what they're really trying to achieve is they want a peaceful surrender, which should be the same thing that any handler wants. Um, so what they're saying is by giving the warning in a sufficient amount of time, you increase the likelihood that this will end a voluntary submission by the suspect without a dog bite, without the dog getting hurt, without you getting into a fight. That's the goal we want. Okay. So that's why they want the warning given. It's giving the defendant fair opportunity to comply and submit. So, what should a warning include? Typically, these elements. Obviously, your authority, number one. Number two, very important, what it is that the suspect is being required to do. Be very clear about it. Whatever it is, walk out to the sound of my voice with your arms extended out to your sides. Walk out to the sound of my voice with your fingers laced behind your head. facing me. Walk out to the sound of my voice with your arms extended and lay flat on your stomach with your arms extended and your legs spread. Whatever it is you want them to do. I mean, it doesn't matter. It's just that you have to be crystal clear about it. Okay. Number three, and also while we're on number two, when you repeat the warning, don't change the instruction. Because once you do, in any way, and somebody gets bit, they're going to come into court and say, well, he confused me or she confused me. Because first she told me to do this to avoid getting bit, but then she told me this, and I did the first one and I got bit. That's going to be the argument. And they'll play back your warning. And if a
Oh, I
jury
bet.
hears that they got two different instructions and they followed one of them and got bit, it's not going to go well. So be very precise and keep it consistent. All right. Number three, announce the presence of your dog and the fact that the suspect, very importantly, will be bitten if they don't comply. Some agencies, and I think I know what motivates it, have told handlers to use a warning that says you could be injured, you might be bitten, you could be bitten. That is a disaster waiting to happen. Don't equivocate, don't qualify it. Number two, you are telling them exactly what they have to do to avoid that outcome. Okay.
Got
And
it.
number three, you're saying if you don't do it, I'm going to release the dog and you're going to get bit. So again, if you qualify it and you say, oh, you might be injured, you could be hurt, you could be bit, they're going to come into court after they get bit and say, well, he said I might be injured. He didn't say I was going to get bit by the dog. I thought, this meant that. And these are just arguments they're going to raise that you can eliminate by being clear in the warning and being uh, unequivocal about the fact that they will be bitten. Because if you have to release the dog because they don't comply, there's only two outcomes. One, they don't get bitten for some reason. The dog doesn't bite them. Okay, great. We don't have a problem. Or the dog does bite them. That's exactly what you told them was going to happen. There's no confusion. So I always say to be clear and let them know they will be bitten. Because if it's something less than them getting bitten, that's going to work to your favor,
Yeah,
not
no sweat.
okay. The warning has to be given in a manner that's likely to be heard and understood, not guaranteed to be heard and understood. Likely. The courts don't hold you to a guarantee because there's just too many factors that can influence whether the warning is heard and whether it's understood. But they want to know that you gave it in a manner that's likely to be heard and understood. How do we determine that? That is a determination that has to be made by each handler based on, excuse me, the factors of their deployment area. You know, the build, if it's a building search, are you in a, you know, 8-room schoolhouse building, one floor with acoustics? Are you in a 40,000 square foot warehouse that's got machinery humming and it's loud and there's multiple floors? So you have to evaluate the area of the deployment to determine what's likely to be heard and understood. It doesn't have, it's not a science. The court's not holding you to perfection. They just want you to be able to satisfy them that any individual on the other side of that had a fair chance to hear and understand the warning. Okay. And that goes to the next point, which is the warning needs to be repeated for the most part. If you're in really exigent circumstances and you don't have time to give a warning and wait 30 seconds and give the warning, okay, then you don't. But typically, if it's not that exigent, the warning should be repeated with adequate time in between for compliance. Okay. Because again, the goal of the courts is peaceful surrender. So if you rattle off the warning and go one, two, three, and boom, your dog's on his way, no court's going to believe that that provided adequate time for compliance. So they're going to say you wanted that outcome, you almost designed that outcome. So if you've got a perimeter set up and now we're talking more about public law enforcement, obviously. And this guy's not going anywhere. Who cares? What's the rush? Give the warning
Yeah.
3 or 4 times. Give, a minute in between each warning. Um, there's not a rush if the guy's not going anywhere, if it's not exigent. Okay. Let me go back to likely to be heard and understood for a second. I was monitoring a building search venue at a training event, and there was a deputy sheriff from a department who ran this venue. And as he was coming out, I stopped him and I said, "Can I talk to you outside for a minute?" He said, "Sure." He said, "Did I do something wrong?" And I go, "Well, I just want to ask you, is the manner that you gave that warning, is that how you give the warning typically, or did you alter it for the training venue purposes?" And here's what I mean by that. Any of you been through training and waited online to run a venue, you can't take 20 minutes with each dog because you're going to be there till midnight,
Right.
right? So people abbreviate warnings, they cut certain things short. I get it. But what I'm asking him is, in the field, is this the way you're giving the warning? And he said, no, that's how I would always give it. Was it bad? And I told him, I said, I was standing 10 feet away from you. I did not understand one word in your warning, like not one. And he looked at me with shocked. And I said, you said it so fast. It was
Yeah.
unbelievable. He sounded like an auctioneer, like that fast. And I told him, I said, if that gets played back in court, nobody's going to believe that that warning was likely to be, well, it might have been likely to be heard, not understood.
Not understood.
So I said, if you just slow it down, I think you'll be fine. And the next time he came, and he wasn't irate about it. He was glad I pointed it out because he wasn't even aware he was doing it.
Yeah.
And when he ran it the second time, he did slow it down. The warning was fine, it was perfect. So that's just bears on this likely to be heard and understood. Um, One thing about likely to be heard and understood, your dog cannot be barking through the announcement. Because if all a jury hears is you every fifth word and the rest of it is your dog barking, they will not believe that the warning was likely to be heard and understood.
I'm glad you mentioned that. That comes up in training all the time. All the time. And I hear a lot from handlers of, well, I want the bad guy to hear my dog barking. I get that, but not during the instructions or not during the warnings.
No, and listen, you can be creative. I had a handler tell me, he was very honest. He said, "Mr. Peters, I have trained to that and trained to it and trained to it, and I cannot get him to shut up during the announcement. He's too amped up." So what I do is I leave him in the squad, I give the warnings, and then I go and get him. That's fine. You can do that.
Exactly. Yeah.
Your perimeter officers can give the warning if they're there. It doesn't have to be you. You have other officers on scene, they can give the warning. You can give it from a patrol car PA. You can give it from a helicopter PA if there's one on scene. It's just likely to be heard and understood. That's the only rule. So
Got it.
be creative. But if the dog is barking through that warning, yeah, no, that's not good. You have to figure out a way around it. Either the dog's got to be quiet or um, you got to use one of these other approaches. Now, I knew a handler had the opposite problem. Well, I don't know if it's a problem. He said, "John, my dog is always silent through the warning, but after I give it the third time, I deliberately fire him up. So the guy knows I'm not kidding and I do have a dog. And that usually results in him coming out." Well, that's fine too. I mean, nothing wrong with that.
Got it.
Um, they're not required when officer safety is at risk, but understand that that's the exception and not the general rule. They want the warnings given, but they place a priority on officer safety above a warning. So what does that mean for you? You have to document. If you chose not to give the warning for officer safety reasons, in your report, document why you did not feel safe to give the warning. Okay? Be thorough about that because, like
Gotcha.
I said, it's the exception, and they're going to make you defend why you didn't give it. All right? We're good here
Yeah.
on warnings? Okay. So let's talk about generally use of force issues. I know guys can't ask the question, so I'm going to handle this question and answer from me. Um, Courts are more focused now on time on the bite versus the initial decision to deploy the dog to bite. So if you're in trouble on a bite, it's going to be because they felt the dog was on too long. More and more cases coming down all the time on this issue and penalizing handlers, sometimes very unjustly. But it's clear that the courts don't want that dog on 1 second longer than it needs to be. So you have to be really alert to what's happening with the suspect and when it's time to remove the dog. They are not asking you to get the dog off prematurely. They're not asking you to remove the dog while the suspect is still representing resistance or a threat. But once that suspect is under your control, no longer a risk of harm or flight, they want the dog off. That's what they're telling us. So,
Gotcha.
uh, verbal out versus physical removal of the dog. This is a trend that's kind of disturbing to me from a legal standpoint. I see a lot more use of physical removal. Is it good? Is it bad? Look, there's a place for physical removal and there's time for physical removal. My concern is handlers training to the point that it's the only tool they have in their toolbox. They cannot verbally disengage their dog. I think primarily you need to have verbal control of the dog, and physical removal is a backup, or it can be the priority depending on the circumstances. What are the benefits of a physical removal? The benefits are you are shutting down the engagement and not leaving it up to the dog. He doesn't have the option. If you do a proper physical removal, you're minimizing the damage that could be done to the suspect. And the courts want that. They want it minimized. So, and the third thing I would say about physical removal is it prevents a rebite if the dog is controlled properly. Um, so those are advantages to physical removal. But let's talk about what's not an advantage. And let's talk about it from a tactical standpoint to begin with. If your dog is engaged with a suspect 30 feet from you, what do you have at that point? You have distance, right? What's distance?
Hmm.
Distance is safety, okay? And you have time to evaluate if it's safe to approach the suspect and remove the dog. You have distance, you have time, you have the thought process. If the only way you can shut down the engagement is to run up and physically remove the dog, you're forfeiting that advantage. You don't have the distance now. You don't have the safety that the distance provides, and you don't have time to sort it out at a distance. You're gambling that it's safe to go up and grab the dog off the suspect, and it may not be. Okay, but you don't have a verbal option anymore, so you've left yourself with this is your only alternative.
Just that one option, yeah.
Um, I've had handlers tell me, they're like, yeah, but I don't want a dog recall to me 30 feet and then this starts all over again and the guy takes off. Okay, don't. Out your dog and down him right by the suspect and have him watch the suspect while you move up and evaluate. If the guy starts to take off, he's not 30 feet away. Maybe he's 4 feet away from the guy.
Yeah.
There's ways to do it. But the courts also want to know why you can't verbally out your dog. And there are court cases on this. There was one just this year it was out of San Jose. It's a really ugly inability to shut it down. It then involved lack of verbal control, couldn't physically remove them, couldn't electric collar him off,
Oh,
nothing.
wow.
And there was a lot of damage being done. So The courts are looking at it. So yeah, I wouldn't say verbal out versus physical removal. You should be able to master both of them, but it shouldn't be an either or. That's all. And
Gotcha.
look, if you don't have verbal control of your dog, and now this dog is doing damage to the suspect, and it's time for him to come off, and you're negotiating with him, like, please come out, please do, and he's tearing this guy up. That's a much worse result than if you went up and physically removed the dog from the legal standpoint, because the courts want it to end when the guy no longer represents that threat of harm or flight. Okay. Bite of an innocent person, and I think somebody specifically raised this question. So let's talk about it in both contexts. Obviously, in the law enforcement context, the bite of an innocent person is considered a seizure of a person under the Fourth Amendment. Even though you didn't intend for the dog to seize them, it is still considered a seizure under the Fourth Amendment. The next level of analysis is, was it a reasonable seizure? Now, that sounds kind of silly, right? Like, how could a dog seizing an innocent person be reasonable? I'm going to give you an example. We talked a little bit about it earlier. Let's say you've got a known violent suspect that is being pursued, and he's got a knife in his hand, and he had used that knife on somebody prior to you catching up with him, and he's in active flight, and he is moving towards a playground where there's children. You cannot get to him before he gets to that playground, but your dog can. You decide to send your dog, and some innocent person happens to intersect the path of the dog, and the dog decides they're going to bite that person. That could still be considered reasonable action on your part, because not releasing the dog could have led to a worse outcome for those children in the schoolyard if the suspect was able to get to them. Okay. So that's kind of how that analysis goes. It's always considered a seizure. The next analysis is, was it reasonable? Meaning the action of releasing the dog in the first place. Let's take private security. You're not subject to the Fourth Amendment. So for some reason, you use your dog to apprehend a suspect, say in a parking lot of one of the casinos. Um, they decide to sue you. Well, they can't sue you under 42 USC 1983 or for Fourth Amendment excessive use of force, deprivation of their rights. They'll sue you for either assault. Well, not probably they will. They'll sue you for assault and battery, and they'll sue you for under a negligence theory that we discussed before. So
Gotcha.
what is an assault and battery? Well, it really rolls back to the Fourth Amendment, because under the Fourth Amendment, excessive force is always considered an assault and battery. So you're kind of back there, but it's just not analyzed under the Fourth Amendment, which is better. If you're in private, you're in a better position, trust me. So that's how that will go down. Um, Searching for a missing person with a bite and hold dog. This is going to apply obviously largely to law enforcement, maybe exclusively. This came to me because a handler in an agency used a bite and hold dog to go in search of an elderly woman who had been missing. It was an off-lead search, and the dog got on top of a brush pile pursuing the scent and fell through the brush pile and landed right on top of this poor woman and bit her. Not bad, but he bit her. And the command said, we're never using these dogs in that role again, and whatever. So how do you deal with that? Because there's bad potentials either way, right? My suggestion is this. You want to show the court in the form of a report that you went through a list of considerations before you went in search of this person with a dog that you knew would bite them if it found them before you could restrain the dog from biting. Some of those elements are, what was the age, mental health, and physical condition of the person who's missing? Second one, how long had they been missing? Third element, what were the terrain considerations? What were the weather considerations? When was the next available daylight coming? How long before daylight would come? Or how, what was the remaining daylight before you were going to be in darkness? Start showing a list of those factors and what your conclusions were, what was known. And then lastly, what other methods had been pursued and what were the results of those methods? And you're going to come to a final conclusion, which is it's better for us to go in search of this person, even with a bite and hold dog, than it is for us not to go in search of them. They are at much greater risk if we don't make the effort to find them than if we make the effort and they accidentally get bit. Okay? Because if you can show you went through that analysis and it leads to that conclusion, court's going to give you qualified immunity every time. Okay?
Makes sense. And just so you know, we're up on that 1 hour mark that you
Okay.
mentioned, but I do have one quick question from you or for
Yeah,
you from a handler. I'm getting them in text messages as well
sure.
as in the chat group. The specifically is what are the consequences or what is your take on handler protection? Number one, a deployment of a dog for someone running away, as opposed to handler protection. The dog, you're just taking the dog for a walk, and there's some type of agitated person that attacks you. What what kind of differences do you see that? And that's specific to private security.
Now, oh, specific to private security?
Correct. Yeah, this question's coming from
Okay.
private security out of California,
Or,
and more of just, you're walking your dog, and then a crazy guy comes out and wants to fight you.
okay. Now, is this walking of the dog while you are off the job or you're on duty?
You're on duty and
Okay.
basically doing detection work. You're searching
Okay.
for your bombs, whatever it is, but
Yeah.
you're at a concert venue or wherever you may be, and then all of a sudden, um, somebody wants to fight you or because they're drunk or whatever reason. How does
Well,
that change things?
yeah. So it's going to depend again on whether you have the luxury of any time at all and what the nature of the attack is, right? Like if they're coming at you with a knife, court's not going to require that you give a warning, you know? If
Right.
you can, but you may choose not to release your dog if somebody's coming at you with a knife for the protection of your dog. I don't know. These are decisions that are going to be kind of split second, right? Um, so again, you go back to whether you acted reasonably, and depending on the nature of the attack. So let's take two extremes. Somebody comes up to you and they're standing about 4 feet away from you, and they're like, "You're an asshole," and I ought to kick your butt, and blah blah blah, and it's just they're trash talking, right?
Yeah.
They
That happens
could,
about once a week for most private security.
yeah.
Yes.
So it could result in an actual physical attack. It could escalate to that. But at that point, you've got a little bit of time to A, evaluate and B, react short of immediately releasing the dog on the person. That's when a short warning is appropriate. Like you don't have to go through a big long warning. You should just tell
Right.
them, look, what you're doing is I'm not feeling safe. I consider it a threat. And if you don't discontinue, um, I may have to release my dog, something like that. Or let's take the other extreme. Somebody's running at you. They're running at you and they've got a weapon. Let's say they've got a club and they're yelling that they're going to kick your ass. Do you have to wait? No, you might very quickly say, stop, or I'm going to release the dog. And then the next thing is you got to release the dog. Okay. If you're able to even get it out, you might not be in a position
Right.
where you're able to get that out. I argued a case in the Sixth Circuit where there was a case actually out of the Fourth Circuit where this was law enforcement now, but the same principle applies. He stopped a motorist and he believed that the guy was armed with a gun. And he had his dog out of the car and he just immediately released the dog with no warning. But the court found that those were exigent circumstances and that he could have ended up being shot if he had taken the time to give the warning. That there was no time, right?
Gotcha.
So each handler is going to have to evaluate that moment on whether it's okay to release the dog for their own protection. It is okay to release the dog for their own protection, but it has to meet the circumstances.
And
And if
specific to
you
what you
have
mentioned before, a certification for handler protection or apprehension would be helpful. It doesn't solve all the problems, but I would think that that would be helpful if you're actually certified to do handler protection and the dog is acting under that.
no question, because they
Excellent.
are going to look back to that. They're going to look, how were you trained? What did your certification require? Or were you never trained in this situation? Well, if you were never trained what to do and the dog bites somebody and then they sue you, they're going to sue your agency too. And it's not on you anymore. A court's not going to hold you responsible. They're going to say, you didn't give this guy any guidance.
Right. And I've seen it before on at least when we do reality-based training. We have single-purpose dogs, Labradors, German short-hair pointers, clearly not certified or trained to do handler protection or apprehension, but then we'll have a decoy pop out and attack the handler. And these German short-hair pointers are still a dog at the end of the day.
That's
And it
right.
may be a fear bite, but they're going to put a bite on somebody as well. I would
Yeah,
think the court looks at that a little differently as well.
I agree.
Okay.
So I guess I'm not giving you a lot of mathematical precision on this,
That's
other
okay.
than it's a permissible use of force in defense of yourself, but no different. Really, take the dog out of it and say that all you've got is I don't know, a club or what am I looking for? Um,
Sap or a blackjack or
yeah, you've got a blackjack. Well, you've been authorized to use the blackjack in that situation, for your own protection. Probably, yeah. If the
gotcha.
level of force was, if the level of force being used against you was sufficient, or the threat was imminent and legitimate. It's funny, legally, people misunderstand the term assault and battery. They're actually two different things.
Yes.
An assault is a threat to commit a battery,
Yep.
and it's combined with the imminent ability to carry out the threat. That's what an assault is. The battery is the actual physical contact. So if the assault is credible, the threat is credible with the imminent or apparent ability to carry out the battery, yeah, you have a right to defend yourself. And look, not every
It still
judgment
falls under
call,
Graham if you're law enforcement, correct?
right? Not every judgment call is going to be made 100% correctly. It's not. You can't train for every single situation. So it's a judgment call, but you have to fall back on your training, your certifications, and what the circumstances of that encounter, were driving. But
Gotcha.
I will tell you that the courts will always defer, even in the case of private handler, to handler safety. They will always defer to that.
Excellent. Well, we have about 50 minutes left, so we can take a break if you like for
Yeah,
a couple
let's
minutes.
take, I want to give everybody just like 5 minutes, just kind of clear their heads and maybe get up, stretch, whatever. But we want to get through the material for you. And so I've got, well, your time would be 4:10. No, wait,
Correct.
4:10. Yeah. So why don't we come back about 4:20? All right,
Uh,
let's come back about 4:15, if that's
let's do
okay.
4:15. That's perfect.
Okay,
Excellent. All right, we'll see you in 5 minutes.
you got it.
All right, John. Looks like
Ready
our
to
break
roll?
is over and we can go ahead and get started.
Okay, just kind of a heads up. I was going through the remaining slides. Do you know, is anybody out there a supervisor?
We're going to have quite a few supervisors. We also have quite a few owners of third-party private security as
Okay,
well.
good. Okay, I just want to make sure we covered what we need to cover. So let's get into canine sniffs of personal property. Now, this is not the individual, this is the property, right? So, a couple things I want handlers to be aware of. I get this question from handlers a lot. Like, what will the courts, what do the courts require and what do they require final response? Do they require? Here's the bottom line. The courts don't know any of this, okay? They count on us to educate them. Unfortunately, we don't have any universal set of terms used in detection work. And you see in the second bullet point, they're all over the place. Interest
Yeah.
alert, final indication. I've seen profound alert. I've seen response. They're all over the place. But the good news is it doesn't matter because the courts don't even know what those terms mean. So what's important is this, and this is the short route to get you where you need to be on this. Handlers get in trouble when they either use one term to describe multiple changes of behavior or they use multiple terms to describe the same change of behavior. Then the
Gotcha.
court gets confused and they think you're basically throwing stuff at the wall. Okay. So the more precise and consistent you can be, the better off you're going to come out of these situations. You should have a term to describe a physical change of behavior with your dog, and that term should describe the same physical change of behavior in training and on the street. It should be consistent all the way through. Okay. Don't change them up. I don't care what you call it. You could call it a Big Mac. The court doesn't know what they don't know what it means. So just be consistent with the term you use and pair it to a specific behavior. Courts generally across the country do not require a final response for probable cause to search. Alert is almost universally accepted as long as you can describe to the court why you know that alert or that physical change of behavior is reliable. And how are you going to prove that? You're going to go back to your training records. That's why it's important to have good training and good records of the training. Okay. One handler got hung up in a matter where he was trying to argue something less than a final response as alerting him or telling him that his dog was in the odor of narcotics, but they looked at his training records and he consistently relied only on a final response for that. So if you're tied to a final response in your training records, that's what you're going to have to produce on the street and in your reporting. Okay.
Got it.
Um, let's go to, okay. This is a new trend coming up. Um, Courts are really starting to penalize handlers whose searches and seizures follow an alert by the dog or response after the dog is on a vehicle. Nose contact, standing on the vehicle, paws on it, sniffing, that kind of contact. Okay. But not in every case. And here's the elements I want you to understand. The court's going to look at whether the contact was inadvertent and accidental, or if it's directed contact by you, or it's trained or encouraged. Okay. So, what's an example? There was a case where a dog went up high to scent a vehicle that was stopped for a traffic violation. On the way down, just because of gravity, the dog's paws caught the side of the car. He braced himself, but then he got down right away and he continued detailing the vehicle. There was an alert later at a different point of the vehicle. The court did not penalize them for the contact because, in the court's view, that was just physics at work. It's the way the dog is falling,
Right.
and that's what caused the contact. It wasn't directed by the handler, and it's not trained to do that. The second element is whether the contact is limited in time, or is it a prolonged contact, or is it being repeated at different points around the property being sniffed? And lastly is whether the alert follows the contact at the location of the contact, or is that alert occurring at a different point in the process of the sniff after the contact has occurred? So if it's occurring immediately after the contact, the court's going to consider that the contact is the source of the alert. If it occurs in a different point, the court will probably excuse the contact and say, no harm, no foul. It really didn't lead to the detection of the odor. Same thing with that second element. If the dog's on there a long time sniffing to try to ascertain the odor, and then there's an alert, the court's going to draw a direct line between the two things. So,
I suspect that this um, doctrine, if you will, has been very specific to narcotics thus far. Is it
yeah,
going to generalize to the explosive side of things as well, do you think?
no, I don't think it will. And we'll talk
Okay,
about that. We're going to get to EOD and I'm going to show you the distinction.
cool.
But this is just something I want narcotics detection handlers to be aware of. They don't want the dog's nose on the car. They don't want the dog's paws on the car. The rule is generally this. As law enforcement, you cannot trespass onto property for the purpose of obtaining evidence of a crime unless you have the owner's consent or a warrant or probable cause. It's got to be one of those three. So this came up in the context of dogs making inadvertent entries through openings that are left open by the occupants of the vehicle, dog jumping through it during an exterior sniff. Um, the courts are saying the same thing. They're saying, as long as you can satisfy us that your dog was already in the odor of narcotics before he entered through that opening, it's okay. If not, it's not okay because you're conducting the dog is conducting a search. He's crossing that threshold. He can do that, but only when you have probable cause or the owner's consent. So you've got to be able to articulate for the court what was the change of behavior in your dog that told you your dog was in the odor of narcotics. Once you can establish that, that's the probable cause. Then it doesn't matter how the dog entered the car. You can put the dog in the car.
Gotcha.
Okay? All right, here we are with EOD. So, yeah, law enforcement EOD has the greatest Fourth Amendment privileges of any canine team. And the reason is there's a more compelling societal or governmental interest at stake. What is that? Mass casualty, uh, massive property destruction. People look correctly or incorrectly. The optics that people have about narcotics death, let's say, versus explosive death, is that in narcotics, the victim elected to take narcotics. And nobody forced it on him. He elected to take it. He took it for an extended period of time, and his death was gradual due to decline of his health. He never sought treatment. He had that option. He didn't seek treatment. Um, with explosives, they look at it exactly the opposite. The victim had no choice or say in the matter, no control. They were typically in the wrong place at the wrong time, and they're a random victim. And that scares living daylights out of people. So consequently, they are willing to give you a lot more of their Fourth Amendment space to operate in. And the courts are as well. Um, that applies both in public and private settings, by the way, not just for law enforcement only. An alert by an EOD canine is probable cause to search. In some cases, a warrant may be required, but if you can establish the exigency factor, Courts are going to give you a pass on that. EOD teams, you're just like narcotics detection teams. For that sniff to be valid, you first have to be legally present at the location where you're conducting it. The property that is the subject of that sniff has to be in a public place, or you're given consent by the owner of the property to do the procedure, and that detention cannot be unreasonably long to do the procedure. There's a distinction. You mentioned it earlier, Ryan, about what about backpacks, purses, etc. The courts distinguish between property that is attached to a person, like a backpack or a purse, or property in a common area, like checked luggage, postal packages, so forth. Even on a bus, the courts treat baggage that is kept with the passenger in an overhead compartment or on their person in the seat totally different than they treat the luggage that's checked in the bay of the bus. Okay. The luggage in the bay of the bus has a much lower expectation of privacy. Property attached to the person is seen almost as an extension of the person, and that the person expected it to have a higher privacy protection.
Interesting.
Now, vehicles, I'll talk about this briefly. I get this question a lot. It's a traffic stop, you're ordering people out of the vehicle. A woman grabs her purse and she's getting out of the vehicle with it. Can you order her to put the purse back in the car? Typically not. If you're getting ready to run the dog, the courts look at that as that's just you're using a method to try to get the right to search the purse by having it in the car when the dog goes around it. Now, if the person is in the vehicle with it, or if the person leaves that in the vehicle, you run the dog alerts, and now they say, oh, wait, I want to get my purse out of the car. They can get it out of the car, but it doesn't excuse it from search. It is still subject to search because it was in the car at the time of the alert, and the alert is probable cause to search anything that was in the car at the time, any property. Property.
Got it.
All right. Yeah, you can do a directed sniff of property anytime you have reasonable suspicion or probable cause. On a vehicle stop and a traffic stop, you don't even need those to do the exterior sniff. As long as it happens in the window of the traffic stop and the officer remains busy processing the traffic stop.
Not delaying the stop just for
Can't delay
canine.
the stop or interrupt it just to take the dog around the car. Okay. These are just, I'm not spending a lot of time on this, just Supreme Court case where it makes it clear that they're going to treat explosives detection different from narcotics detection. Okay.
Awesome.
Something called the special needs doctrine. Okay. Uh, Here's another thing with respect to private security. Private security has this edge when it comes to explosive detection. Many facilities put people on notice that as a condition of entering the facility or the event, they are subject to this procedure. Okay, free air sniffs. Sometimes it's posted, sometimes it's printed on the admission form or the ticket. And if they elect to enter with knowledge of that, then that's a waiver of any right they would have had not to be subject to it. They're making a conscious choice. No, I want to go to this event or I want to enter this place. Okay, I agree to be subject to this procedure. So it's not a violation of their right because, they made a waiver of it. And in the private context, they don't get to determine that. The owner of the facility or the venue gets to determine that.
So be it a
Um,
hotel or a casino, having those signs posted at entrances, at least the public entrances, would fall under the
yeah,
right thing to do. Got it.
absolutely. Yeah. And then an alert under those circumstances can lead to them being detained or searched with or without their consent. That can be placed in that as well. So, because again, remember, we're in the private sector now. We're not operating under public law enforcement. So private sector is given a lot more flexibility in the rules by which they operate that business or that establishment.
My
Um,
experience with casinos and hotels, specifically here in the US, is the legal departments are very hesitant for security to be searching people almost without consent. But
mhm.
the common, I guess, remedy for that is common amongst almost every brand that's out there is security will contact them, ask them if they have anything that they're not supposed to have, any kind of explosives, firearms, etc. Of course, most of the time they say no. They ask for consent to search. If that person says no, I don't want to be searched, we then just trespass them and get them off the property, and we don't force that search.
Okay.
Any issues with that? Any extra liability?
No, I don't. I don't, except that if you put them off the premises and then it turns out they did have an explosive and they set it off in the parking lot or something, you know what I mean? Now they're going to say you should have searched the person. So it's kind of a, you can't win. Um,
Fair enough.
maybe the proper procedure, if you really expect that they're in possession of explosives, illegally in possession, then that's when you bring in law enforcement. That will not make you a government actor because it comes at the conclusion of the process. But that's your call, you got to decide that.
Gotcha.
Yeah, and Fourth Amendment concerns, as I pointed out several times, they don't apply to private security in these businesses. Okay. Reliability and liability. Okay. In the EOD context, whether you're law enforcement or private security, you're most likely to be sued if something goes wrong, if explosives are missed and people get killed or injured. It's not typically going to be because you found explosives and seized them. It's going to be because you didn't and somebody got hurt. And then that's going to implicate your training, the reliability of the team, certification, all these factors we talked about, right? Law enforcement will also be sued under a Fourth Amendment claim for an unreasonable search or seizure of a person or their property if they elected to go forward and do that. It may happen, it may not prevail. And as I pointed out before, private security is going to be sued under a negligence theory, not Fourth Amendment.
Got it.
Standards and synchronization. This goes to what I was just talking about. So think of this like your spinal column, where you want all the discs in proper alignment so that your limbs work properly and your systems work properly. In law enforcement and canine, it starts with the law. Canine agency policy should follow current law, meaning you need to stay up on the law because the law is changing. And then the policy needs to be adapted to be current with the law. The training has to match the policy. It has to train for what the policy is. And then I say standards can't be flexible, okay? You can't go, well, he sort of qualified, he sort of didn't. No, you either qualify or you don't, or it's not a standard. A standard is not a bouncing ball. It's a fixed object that you have to train up to and meet. Um, and then your deployments should match the training. So everything should flow in that order. The law leads to the policy designs the training, and the training results in the deployment. So those are all the things that are going to be tested if you ever go to court and get challenged. Okay. And here, this last thing is what I just said. If you got a team that fails in a certification, you don't throw them, to the wolves. You work with them to train up to the standard, but you don't lower the standard so that they meet it. Okay. That's very important. For private security, yeah, these are all important considerations. What does your employer require in the use of the dog? What does the establishment require? Okay. Um, which conditions will require you to involve law enforcement? Any at all? I don't know. That's something you have to review and decide. And who will prepare an incident report when law enforcement is involved? Is it going to be on law enforcement? Are you going to prepare it? Are you both going to prepare one? Are you going to get together and coordinate on that? These are all just considerations I want you to think about. Okay.
Well, something that comes up a lot in private security, especially on the EDD side, is okay, our dog alerts. Who, as third-party security, let's say we're working a concert or at someone else's casino, our dog alerts. What is the protocol? Who do we tell that we have this alert? Is it
Hmm.
only internal? Do we go direct with bomb squads or law enforcement? And every client generally has a different wish. Some don't
Okay.
want us to tell law enforcement. They want it to be basically an NDA that goes to their security to make a decision on what to do next.
Okay. Well, that's good because they're giving you clarity on what the protocol is versus you're left to guess and you make the wrong choice and they're ticked off or whatever. I mean, so yeah, that's what I meant earlier in the presentation when I said it's really important that the agency or the employer be on the same page with the establishment about what goes down in these various situations. Then just these things get eliminated, these mistakes.
Got it. But do you see any additional liability for the third party security canine handler who follows what the client asks of only telling their security department, and then, God forbid, a bomb goes off and we did not, as the third party handler, didn't alert police or whomever? Is there added liability to that,
No,
or is it?
I would say there's no liability because the establishment has the decision making. They can tell you what you can and cannot do or how you're going to operate. And if your agency is opposed to that and says, no, there's no way we're doing it that way, that's got to be figured out at the front end. Because
Gotcha.
if your agency is saying, oh, no, we're not doing that, we're contacting law enforcement every time, and the establishment is saying, oh, no, you're not, you got to get past that obstacle or
No,
there isn't going to be a working relationship,
well, I'm
right?
very glad you clarified that because I hear from owners of private security companies a fair amount that are worried about that added liability if their handler does not call law enforcement. So thank you for
Well,
clarifying that.
yeah, then I think, like I said, it's not that the agency has to bow to the establishment. They can decline the engagement. They can just say, look, we cannot operate under that protocol.
That's
We
perfect.
we
Thank
have to
you.
notify law enforcement for our own protection.
Right.
All right?
Thank you. So I forgive me for slowing you down there, but
No, you're not.
that
It's
clarification is
fine.
super important to a lot of the ownership side.
Yeah. Um, okay, obviously your records are essential for court purposes. They're going to reflect training, they're going to reflect deployment factors, they're going to anything that could be challenged, your records are going to have to respond to, whether they're training records, field deployment records, whatever records, okay? And you want to be able to establish those things I mentioned. You are compliant with your agency's training and protocols. You're compliant with the establishment's rules, and you're compliant with industry standards for what you do. Okay. Um, I also recommend having a training officer record trainings versus the handler themselves because it just takes the handler out of the accusation that he's fudging records to protect himself. Okay. You get a third party like a training officer saying, no, I was there. I supervised the training. This is the performance I saw. This is the outcome I personally saw. So it's helpful. Um, have your records backed up regularly. Always have a backup copy. Electronic, paper, it doesn't matter, but have a good backup copy of your records because God forbid they get lost, and that can happen electronically too. Something happens and you don't have a backup copy of your records, you're at a real uphill challenge when you go to court. So you don't want that.
Absolutely.
Create all records as close in time to the event they're recording as possible. Two reasons. Number one, the further out you get from the event, the foggier your recollection of the event becomes. So you may lose essential points that would have been helpful to you if the matter went to court simply because you forgot them and you never recorded them. And the second thing is your perception of the event will change the further out you get from it. Your best recollection of the event is the closest in time to the event. And the further you get out, it's just how our brains are wired. You're going to have less and less recollection. Okay. Do you record training failures? I get this question a lot. Yes, absolutely record them. However,
Nice.
in addition to recording the failure, record that you noted the failure, record the remedy that you developed for it, show that you applied it, and show the outcome. Maybe the first time it didn't work perfectly, so you did something else, and then you got it, taken care of. You'll get far more credit for showing all of that than just saying, "Oh, my dog never makes mistakes," not even in training, right?
Nobody
That's the
believes
whole
that.
point of training. I mean, I always tell people if you're not failing, you're not learning. That's for darn sure. So don't be afraid to record those. Okay, briefly, supervisors. It's hard to sue supervisors. It's very difficult. And the fact that one of your subordinate handlers may have been negligent and injured a person as a result is not enough to implicate you. It has to be something, a practice or custom that you established in the unit that led to that outcome. Okay. Um, or something you failed to have in terms of a policy. For example, no policy requiring a warning before the dog is released. That could be considered supervisory negligence. Uh, and when I say policy, it doesn't necessarily mean it's in writing. It can also, like I said, be the failure to have the policy, or it can be simply the way things are done and understood to be done within the unit. That's what they refer to as a customer practice. Okay. If you have this customer practice going on, you're aware that it's going on, you don't take any steps to remedy it, and you're kind of playing roulette with it, like sooner or later something's going to go wrong. It does, somebody gets hurt, you can have liability. The other way is for failure to adequately train your handlers, but it has to rise to a level of what's known as deliberate indifference to the harm that the failure to train is likely to cause. So it's a pretty high bar for somebody to reach.
I would imagine that is a high bar. However, would it make a difference if there were multiple emails and multiple documented warnings from handlers to supervision wanting particular training because they see that there's an issue and it's just constantly ignored by ownership?
Absolutely. And that case that's noted at the bottom of the slide, every supervisor should read that. It is a textbook case about supervisory liability where they held everybody from the chief to the lieutenants to the sergeants responsible for the outcome within this canine unit. Um,
And that would fall for private security as well.
well, it would. Yeah, absolutely it would. Not Fourth Amendment again, but
Right.
under negligence
Negligence.
theory, um, it would also fall back on a supervisor. Because what the courts are saying is, look, it's up to you to give guidance to these handlers. That's not their job. It's your job to write the policy. It's your job to make sure it's being complied with. It's your job to structure the training, to see that the training is going properly. And if you have a handler, as in this case below, sending out notice that he's got problems with his controlling his dog and he needs extra help, and you're telling him, no, we're not going to do it. Well, guess
Or
who's
just
paying for
ignoring
it?
it. Yeah.
Yeah. And
Copy.
supervisors who think they're saving money for their agency, whether it's public or private, by cutting back on training, I always tell them, you think you're saving money, wait till the first lawsuit hits your desk because any money you saved will be evaporate in an hour. It'll be gone. So it's just short-sighted thinking and it doesn't pay off.
Totally
Um,
agree. Unfortunately, it's all too common, certainly on the private
oh, I
side.
know it is. I know it is. So basic duties, I'm not going to spend a lot of time on this because you guys are going to get this. Supervisors, go through this list. These are just basically what your duties are. Okay. They're not things that you can punt to somebody else. If you're a unit supervisor, these are on you to take care of. Okay.
Got
All right. This used to have an image in there. I got to figure out where it went.
it.
All right. Some tips for litigation. Number one, educate your attorney. As I said earlier, you'll probably have an insurance company that will assign counsel to defend you. They will pay that attorney. But that attorney is your attorney. He's not the insurance company's attorney. He's not even your agency's attorney. He's your attorney. So, number one, ask your counsel to attend your training because 9 times out of 10, these attorneys will have had no experience with what you do, and they've got to get you over the goal line. So, they need to understand what you do, why you do it, how you do it. Okay. Have them come to your training. Tell them to bring a notepad and a pen and observe and take notes about what you do and ask questions. That's a great way to educate them. Number two, when you get a copy of the complaint with your name on it and you read it, it is going to tell you in brief form when this incident occurred, where it occurred, and their version of what happened. Pull the records relative to the incident then. Don't wait till 20 minutes before you walk in to testify in trial. Pull them out then and start going through those records. It might have been 2 years since you were involved in this. You're not going to remember it. Start familiarizing yourself with what happened. Look, you may, in going through it, realize, oh, I remember this. I screwed up. Okay, that's fine. You're human. It happens. Don't keep that fact from your attorney. I need to know. If I'm going to protect you, I need to know what I need to protect you from. So don't hold stuff back. All right. Schedule a time to sit down with your attorney and review the facts of the incident because there's two things I want to know. I want to know what you know about what happened and what you can tell me about what happened. But I also want to know who is this person I have to defend? Where are they vulnerable? What are their weaknesses? What are their strengths? What's their personality like? How is a jury going to view them? What do I need to remedy here? What do I need to address? Because you could tell me the worst thing in the world. I'm not going to fall off my chair, okay? I'm not going to throw you out of my office. I'm going to get busy building a force field around you, but I have to know what I have to build the force field. So don't hold back from your attorney.
Gotcha.
Um, yeah, and remember, their ethical obligation is to you. So if you sense this person is unqualified or they're sleepwalking through your case, you have the right to insist that they be replaced. You have the absolute right to insist that they be replaced and do it because this is far too important to be in the hands of somebody who this is just a case for them and they don't really care. Okay, testimony. Boy, I always thought this was all missing when I pulled this slide up. Okay, you will only get one take. There's no retakes, either a deposition or a trial testimony. So prepare ahead of time. Remember that how you appear can have more impact on the listener than what's coming out of your mouth. Okay. Whether it's the opposing attorney, whether it's a judge, whether it's a juror, how you appear has major impact. So be professional. Wear your uniform. I don't know why these agencies tell handlers don't wear a uniform to court. Like, you see these, I've seen it. I've seen handlers come in or just officers come in and they're in a suit and tie, and it's like, what is that? That's not what they're expecting to see. Jurors are expecting to see, they've heard a little bit about it when they're seated as jurors. They're expecting to see a police officer. What does the average person expect to see a police officer? A uniform. That's what they expect to see. Don't give them something else. You start confusing them. They start thinking, did he get fired because of this? Because he's not wearing his uniform. Is he suspended because of this? Is he ashamed for us to think he is a police officer? Is he trying to fool? This is the kind of stuff that goes through their heads. And you created it when there was no need for it.
Would you
Okay?
say that's the same for private security as well for a
Absolutely.
deposition? Okay.
Yes. Yeah, absolutely. Because when you start moving away from that identity, they start thinking you're being defensive and they associate defensiveness with wrongdoing. Okay.
Gotcha.
So wear your uniform. You're proud of what you do. You got nothing to be ashamed of. So,
Excellent.
and make sure it's correct. What do I mean by that? There's no dried mustard stain down the front or dog hair on it. Your insignias, your badges are all on and they're all where they should be. Your uniform's clean, your uniform's pressed. all that stuff. You're shaved, groomed, the whole 9 yards. You got to show up. Um, and find out, for example, when you're going to testify in court or when you're going to do your deposition, to leave yourself enough time to get rest, to eat a meal, and to groom and appear properly. If you're going to get off shift at 7 a.m. and they said, oh, your deposition starts at 9 a.m., no, no. You call your attorney, you tell them, look, that day and time will not work well for me. I've got these dates and times. It's not a big deal. All I do is pick up the phone, call the other attorney. I tell him, look, that's not going to work. Let's pick one of these days. He says, yeah, fine, let's go with this one. Boom, it's done. But if you force it and you don't ask for that accommodation and you show up tired and you show up looking grubby, and you can't think straight, that's going into a permanent record under oath. It's just like court testimony in a deposition. And if you're at trial, well, of course it's going into a record and you're in front of a jury and they're seeing that. Don't do that to yourself, okay? Give as direct and short of an answer as possible to a question, and don't be afraid to say you don't know. That's an okay answer. Don't try to invent one just so you had an answer. If the answer to a question is yes or no, that's the answer. Yes, period. No, period. Not yes, comma, but on another deployment I was on one time, blah, 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 and you're running on for 20 minutes because they're not going to stop you. They will let you talk all day. And they'll have 4 notepads and they'll be writing down all the stuff they never knew about, all the stuff they never thought to ask you that you just fed them, okay? Because you're blabbing away. Don't do that. Short, direct answers, let them ask the next question, okay? Don't become argumentative, irate, or defensive. Remember, this is not personal. It's not personal to them either. You're going to feel it personally, but you got to conquer that feeling. Don't make, if you make it personal, you start getting argumentative or, well, what do you think? Or what would you do? Or something like that. You are playing right into their hands because that's what they want you to do in court in front of the jury. Why? Because what's their theory? You're a bully. You're aggressive. You don't know your job. You've got attitude. And here you are feeding it to them. Don't do that. All right? Uh, why do police officers struggle as defendants? Listen, everybody does. It's a miserable experience. It's a horrible experience. And if you don't think it is, you wait till you're in your first case. I knew a handler from Shaker Heights, Ohio, Rick Mastinardo. I still have his cell phone number in my phone, and here's why. He told me, if you ever have a student that smirks or thinks what you're telling them about how serious this is, you're just making this up, like, or you're exaggerating it, you have them call me. Rick Mastinardo got sued in a case. His case lasted 8 years. His
Oh,
department paid $500,000 in fees defending it. He went to trial. He won the case 8 years later.
wow.
He told me, he said that the verdict was absolutely irrelevant to me at that point because all the damage had already been done in the last 8 years. You know, people accusing you of being unprofessional or worse, going into all your records, interviewing people about you, uh, taking your deposition, asking you every question under the sun about your life, wondering if you might have financial exposure personally, you could lose your home, uh, having people at the department look at you differently because maybe he did do something. It's a miserable, miserable thing, and you never want to be a part of it. And he told me that. He said, "Here's my cell phone number. Have him call me." So that offer's out there. All
Excellent.
right. Your records before court. Understand them before court, right? Don't wait for court. Make it like studying for a final exam. Know them in and out. Don't let somebody trip you up on something because you weren't aware it was in your records and now you're scrambling for an answer. Okay? Pay particular attention to areas that you know you're going to be vulnerable on. Give those extra attention. Cover them with your attorney. Let the attorney know what they need to ask you and how you would respond in court to that question. Have this rehearsed. Don't wait for it to roll out for the first time in court. And trial is the place, yeah, where poorly kept records or no records are going to come back to bite you. It's too late once you're in court to try to explain away a problem in your records or to try to revise them the day before. Not going to work. Okay.
Got it.
All right. FLSA, I know there were questions on this, and I'm going to cover it for you briefly, but this outline will give you a good feel for what the elements are. And like anything else we covered in this presentation, you are all free to reach out to me privately with any questions you have by email. You can call me on my cell, text me, whatever you want.
Thank you for that, John.
Okay. Briefly, FLSA was not originally developed for government employees. It was actually developed for the private sector employees. And the purpose behind it was to avoid abuses of child labor. But it got extended to government employees as well. So if you are a private security handler, the test is anything over 40 hours per week. If you are a law enforcement handler, it is anything over 43 hours per week or 171 hours every 28 days. Anything over that is paid at 1.5 times base compensation unless otherwise agreed to in a fairly negotiated agreement between you and your employer. I highlight fairly negotiated because if courts feel that the agreement was forced on the handlers and they had no say in it and no negotiating leverage, they will not enforce it. They will go back to the language of the statute. That agreement has to take into account the actual amount of work required by the employer, meaning the employer could offer to pay you less than what the statute pays, and you may agree to it, but the employer has to be able to show the court that they did a study of how much time off duty you were spending in caring for the dog, care and maintenance, whatever. So the actual work required was considered by the employer, even though the parties arrived at an agreement for payment of less than that. Okay. Work is defined by three elements. It's required by the employer. It's necessarily and primarily for the benefit of the employer. What's an example of that? Okay, you're off duty with your canine. You take your canine home. You're walking your canine around the block. Is that necessarily and primarily for the benefit of the employer? No, most courts are going to say no. It's coincidentally benefiting the employer, but it's not necessarily and primarily benefiting the employer. Now, the employer requires you to roll scent towels at home for your dog. Okay, that is primarily for the benefit of the employer and necessarily. So the last element, it's an indispensable part of the primary activities of your job as a canine handler. Okay, so the court's going to look at all the factors. Again, there's no hard and fast graph on this. They're going to look at all the factors, they're going to weigh them, and they're going to decide. Now, something I've said so far may be sticking in your head. Why, as a handler, would you agree to accept less compensation under FLSA than what the statute provides? Here's why. Sometimes agencies will say, if this gets too expensive, canine, we're just going to have to shut it down. Canine handlers, in my experience, they have the biggest hearts and they are very dedicated to their dogs, and they will do almost anything to avoid losing that dog and that assignment. Sometimes unscrupulous employers realize that they use it as leverage against the handlers by threatening them. Okay. But sometimes it's just a negotiation, or there may be some other benefit in the negotiations for your job compensation that the employer is granting you. And in exchange, you're saying, okay, I'll take less than the full amount of the FLSA in exchange for this benefit. So those are examples of how it could happen. All right.
But the key there is
Whoops.
they have to agree to it, correct? An
Yes.
employer just can't say, "Hey,
No.
this month we're paying you $14."
No.
Um,
No. And let me, Ryan, why we've got that. That was one of the questions that you sent me from one of the handlers out there, who
correct.
specifically mentioned that, and I think you're a private handler. I'm sorry I don't know you by name, but you mentioned that your employer is paying you $80 a month and they're continuing to whittle away at that. And it was just arbitrarily set by the employer and handed to you essentially. That is not compliance with the FLSA. And that does not relieve them of their obligation. Okay. Um,
And that's because there's no agreement, correct?
Right. There's
Okay.
nothing negotiated, and it's way less than what the statute allows. So here, the statute of limitations, if you're going to bring a claim for unpaid FLSA wages, is 2 years, meaning you can only go back at most 2 years of unpaid wages. You can go back a third year if you can show that the employer's failure to pay was willful. What do we mean by willful? I had one of these cases. There was a string of correspondence going to the employer with case law telling them, you have to pay this. This is what the requirement is. This is what we're having to do with the dogs off duty. And the employer just blew it off. So that's a willful refusal to pay. That gives you an extra year. Okay. What is the compensation under FLSA? It's your whatever you should have been paid uh, times two. Is that making sense? Yeah, times two. So it's not three times. It's you get it double basically. You get double what your unpaid compensation should have been.
Gotcha.
Plus, you get to recover your attorney's fees and costs. And that's unless the employer can demonstrate a good faith excuse for the non-payment. It's hard to do, and the
Well,
courts don't.
especially when it's been documented. And this particular handler, who I won't out, that's the case for them. Uh, Management and ownership was told about this multiple times and specifically advised everyone that nothing was going to change and we're not making agreements. So,
Right. And so it is hard to prove because they're charged with it by law. The law tells them, look, well, it's just like in policing. Now, ignorance of the law is no excuse, right? Well, it's not an excuse for them either. So, and there are severe penalties if employers retaliate against a handler or an employee for pursuing an FLSA claim, including any internal claim, meaning you send a formal demand up the chain of command internally, not filing a lawsuit. That's
correct.
included in the retaliation.
Excellent.
So if somebody sends this up the chain and the next thing they know, they're being removed from canine and their dog's taken away, my argument legally is that is retaliation because retaliation in the statute is defined any action which results in a significant change in the employment status. And clearly that does. Now, I will tell you that many handlers opt not to pursue it for two reasons. In smaller agencies, they understand the politics in the chain of
Yes.
command, and they will tell me flat out, I've got no future in this agency if I plow ahead with this. And they've made that clear to me. Or I don't want to do it because they'll take my dog away from me. And I'm okay. I'll just waive it and keep my dog. I'm okay with it. So you could make that decision. I'm not saying it's wrong. I'm just trying to tell you what your legal rights are here.
Excellent. And since we're
Um,
at the point with questions, I'll just go ahead and read the questions if that's okay and
yeah,
have you answer.
let me just finish with one last question I had
Sure.
written down from the ones you forwarded. Somebody out there is a private police assigned to an airport. And I think the question was, where do I fall in legally?
Well,
Are
and it
you
was, and to be clear, they're a special service officer, so I do believe they are sworn airport police. They're not
okay?
TSA, and they're
Okay.
specifically asking about um, they do EDD sweeps for dignitaries and just around the airport in general. And
Okay.
specifically, we're asking about sweeping employee lockers and break areas that are technically leased by the airlines.
Okay. Well, as long as you have the authority of the owner of that facility, in this case, the airport, to do these procedures, and as long as people frequenting the airport are put on notice that it is, a condition of their presence in that space to be subject to these procedures, or not them necessarily, but lockers, whatever, common areas, then you're going to be fine.
And that doesn't
Even
matter if
whether
it's
you're
employees.
whether you're public or private.
Gotcha. And it doesn't matter if it's employees versus passengers.
No, no, it doesn't.
Excellent. Awesome. We have another question going back to the FLSA. It says the company I work for owns the working dog and pays for some food and vet bills, but told me that I have to pay my own money to board the dog when I use my accrued vacation days. I don't think it's right. I have to pay to store or board company owned stuff, whether it is a dog or a car or a bike. The company owns the dog. Can they legally make me pay for that?
No, they cannot. The only way they could is if you have a contract with them, and again, we're back to fairly negotiated, where you got some offsetting benefit, and as a result, you said, "Yeah, I'll cover the boarding because I'm getting this, whatever it is." And it would have to be a pretty healthy offsetting benefit to justify you having to assume boarding costs for their property. You are not required to pay to store their property.
Excellent. I think you made that pretty clear. At least for on my end. Oh, there's one other question regarding the training records. You mentioned that it's preferable or at least looked upon positively if the supervisor or the trainer is the one actually writing those records. There's a lot of places that don't have their own even supervisors for canine. Many times it's just one canine handler and he's the lone ranger. Um,
Well, is the in the case of the lone handler, is he just doing all his training on his own?
I think unfortunately that's the case in a lot of places. So every
Okay.
hide is known. He puts out the hide and then brings the dog back, he or she, and then of course writes that down in their training records. And they don't really have an option for a supervisor or a trainer, assuming that's still okay as long as they're documenting those things.
Yeah, it's funny in the day and age, yes, it is okay. When I say it's preferable to have that third person doing it, I mean, assuming that's available, right? If it's not available, it's not available. It's not a requirement, it's just preferable. It just helps. That's all I'm saying. In this day and age of technology and video, it's been suggested that there be a system where you actually record the training. And then if you were ever challenged on what's on the paper and you had video to show the dog's performance backing up what's in the records, that's helpful, right? But you're always going to get an attorney who's going to find something to challenge or question. Even if you had that, he's going to say, well, how do I know this isn't edited? How do I know it was
Right.
taken that day? How do I? So there's
It's
no
not
perfect
AI.
system. Yeah. And then this comes back to why well-kept records will help you in court. Because if you have records that are supposed to be kept in regular intervals and record certain information, and they're missing for certain periods of time, there's gaps, or they're not complete. There's certain things missing in the records. That reflects on your credibility as a witness because people think a couple of things. This person doesn't have a very organized thought process. They're not a good thinker. So why should I believe what they're telling me in the stand? They're probably confused because their records are confused. Um, or they left out things intentionally because they weren't favorable to them. So they've doctored these records. Even though you didn't, it was just laziness or carelessness. It could be seen as being deliberate and as being evasive, and you don't want that. So,
Gotcha. I think I've got one last question just regarding accidental bites. So not deployments, just you're walking your Labrador doing detection and somebody steps on your dog's foot and your dog turns around and they're a dog and taps a random person that accidentally stepped on their toe or on their foot. What
Well,
are your best practices on how to handle that?
are you talking about private security?
Either both, actually,
Okay.
if you could.
Okay, sure. Your insurance company is the one that's going to step in and handle that. It's really going to be more out of your hands. In the moment, how should you handle it? What does your employer's policy require in those circumstances? Do they require that you prepare a report, take the name? Do you have to photograph any injury? Do you have to get them seen by medical? I mean, a lot of it is going to depend upon what your employer requires, be it law enforcement or private
I think the
security.
question is, what should the employer, like, what should that
Oh, what should
policy
the
be?
employer do? Okay.
Yeah, like, what should that policy be for the handlers to do?
Well, one thing you don't want to do is show that you just blew it off. I mean, because if that ever comes to court, people won't appreciate that. So you show that you addressed it, but I would just take a name, complete a simple report, date it happened, location, the facts of the incident, the person's name and contact information. Um, I wouldn't ask them for a statement, but it can happen. And I'll tell you this on the liability end, every almost every state in their state law has an exception for a dog bite of a civilian, which is all we're dealing with here. Um, and that is called provocation. Provocation is an absolute defense to a claim. Now, provocation, we hear the word and we think, oh, they're poking the dog with a stick or they're stealing its toy. It doesn't have to rise to that level. It could be
Okay.
anything that's likely to trigger the dog to bite. It doesn't even have to be intentional. So if they accidentally stepped on the dog's foot and the dog reacted, that would fall under that.
Excellent.
Yeah.
All right. Well, I think that about covers it. If you want to put up your last slide there with your contact information for
Yeah.
everybody,
Yep.
that would be awesome. And again, John, I cannot thank you enough for taking the time today to prepare this awesome presentation and taking the time to give it to us today on this webinar. So thank you truly again.
Well, Ryan, you're very welcome. And I just want to apologize to all the handlers out there because we had a short window to work with and a lot of material to try to cover. And frankly, I had to leave out a lot of material too. But again, and I mean this sincerely, I tell all my students, this information is up there for a reason, okay? If you want to contact me by text, by cell phone call, by email, because you've got a question or you're involved in a situation and you want to know what the law provides, please do not hesitate to reach out to me. Anything we covered today or anything we did not cover that you were hoping to have covered, reach out to me, okay?
Excellent. Thank you so much, John. You be safe. I look forward to teaching with you in Nashville here in a couple months.
You
And
got it, Ryan.
until then, if there's anything we can do for you, please don't hesitate to reach out.
Appreciate it. Take care.
Awesome. Thank you. You as well.